You got hit by a commercial truck and now you're stuck with the medical bills while the company pretends it's not their problem. They'll blame the driver, blame the weather, anything to avoid writing the check. I'm DiMartino. I've helped truck accident victims in Indiana hold companies accountable for years. And there are clear legal ways to force them to pay. This video walks you through the 3 most common ones, so you're not left holding the bag for someone else's negligence. Let's start with one of the most common ways companies can be forced to pay you after a truck accident in Indiana, and that's through their insurance. When a trucking company puts a big rig on the road, Indiana law requires that they carry a commercial liability policy. The policy's there specifically to cover damages if their truck causes a crash and leaves people hurt. Picture this: you're driving on I-80/94 near Portage, and suddenly a tractor trailer swerves into your lane, pushes your car off the road, and leaves you with a totaled car and a broken leg. The moment you call 911 and get medical help, that truck driver's employer is on the hook because the company has insurance just for this reason. Here's where things get interesting. A lot of folks think, well, the driver messed up, not the company. But in Indiana, if the driver was working at the time, making deliveries, picking up a load, hauling freight, then the company's insurance stands behind that driver. The law is called vicarious liability, and it's designed so companies can't dodge responsibility just because it wasn't the CEO behind the wheel of the truck. Let me give you a real-life example from right here in Indiana. A few years ago, a woman near Gary was rear-ended by a semi after the driver fell asleep. She had serious injuries. The driver's own insurance was nowhere near enough to cover her hospital bills and long-term therapy. The law firm dug into the trucking company's insurance and found a large commercial policy. A demand letter was sent, backed up by police reports and medical records, and the company's insurance ended up paying for her medical care, her lost pay, pain, and suffering. But you also have to understand that insurance companies, after an accident, don't just open the checkbook and hand you over a check. When an accident happens, immediately they send out investigators. They might call you hoping you'll say something that weakens your claim. I always tell clients, don't go it alone. Get a lawyer who knows how to deal with the insurance companies. We know the games they play. We know how to get them to pay what you're owed. So the first way companies can be forced to pay you after a truck accident in Indiana is through their mandatory commercial insurance coverage. If you're hurt because of a truck driver on the job, that company's insurance is a resource that you absolutely need to go after. Now let's talk about the second way, and that's proving that the company itself was careless or even reckless. This goes beyond what the truck driver did behind the wheel at the time of the accident. Sometimes it's the decisions made by the company that directly lead to a crash. Let me break this down with the story. Suppose you've been in a crash on US 30. The truck driver ran a red light, and it turns out that he hadn't slept in over 24 hours. Later on, you learn that his boss had been pushing drivers to make deliveries faster, even hinting that they should skip breaks if they run behind. That's a dangerous game, and Indiana law does not take kindly to companies that put their profit over people's safety. In cases like these, we can build a case showing that the company itself ignored safety rules. Did they fail to check the driver's logbooks? Did they skip required drug tests? Did they hire somebody with a big history of prior accidents or potentially DUIs? If so, you can prove the company itself was negligent, not just the driver. A famous example in Indiana happened a few years back involving a trucking firm based near Fort Wayne. They had a policy where drivers were discouraged from reporting maintenance problems because it slowed down shipments. One driver's brakes failed going down a hill, causing a pileup that injured several people. When the victim's lawyers dug into the company's paperwork, they found emails showing managers knowingly skipping repairs. The company ended up paying millions, not just through their insurance, but directly out of their own pocket, because a jury decided their own negligence caused the wreck. Here's why this matters. If you only go after the driver, you might get just a small settlement. But when you can prove that the company's own wrongdoing, Indiana law can make them pay much more, sometimes even punitive damages, which are extra payments designed to punish and send a message to other companies. So the second way companies can be forced to pay you is by holding them directly responsible for their own safety failures. If we can prove that they ignored rules, that they skipped training their drivers, or hired unsafe drivers, we can make them pay for the harm that they've caused. All right, let's talk now about the third way, taking the company to court and forcing payment with a lawsuit. I know lawsuits sound scary. Most folks dread the idea of having to go to court and telling their story to 6 or 8 or 12 strangers. But sometimes it's the only way to make the company take responsibility. Here's what the process looks like in Indiana. Let's say you were injured in a truck accident near Maryville, and that company's insurance keeps investigating, dragging their feet, or offering you pennies on the dollar. Maybe they're even denying your claim, blaming you for the crash, or just ignoring you entirely. That's when it's time to file suit. When we file a personal injury lawsuit in Indiana, we have to prove two main things: that the company or their employee was at fault for the accident, and that you have real injuries that were caused by the accident. That is damages, medical bills, hospital bills, lost wages, or pain and suffering. The good news is that Indiana law is on your side if you were less than 51% at fault for the crash. Even if the trucking company claims you came out of nowhere, as long as they were mostly to blame, you win your case. Here's an example. We represented a woman from Michigan City whose car was sideswiped by a delivery truck that merged onto US 20 without signaling. She needed surgery and missed months of work. The company kept saying, "It wasn't our fault. She was speeding." We filed the lawsuit, gathered video from nearby businesses, and even got a copy of the truck driver's cell phone records, which showed that he was on the phone at the time of the crash. Once the company realized that we were ready to go all the way to trial, they settled for a full and fair amount at mediation. But if a company still refuses to settle the case, then it has to go to trial. Indiana juries and judges don't like companies that dodge responsibility, and if they find in your favor, the judge or jury can issue a judgment that forces the company to pay. And if they try to avoid paying, Indiana law lets us collect on that judgment through tools like garnishing bank accounts or putting liens on business property. One thing to remember, there are time limits in Indiana. You usually have to file your case within 2 years of the accident. If you wait too long, you could lose your chance forever. So don't let the fear of court hold you back. Sometimes it's the best way to get justice when a trucking company won't do the right thing. Before we wrap up, I want to make a few points clear. Truck accidents are not your regular car accident. There's usually a lot more money at stake, and the injuries are often much worse because trucks weigh so much more than cars. Companies and their insurers fight hard to avoid paying because they know how high the costs can climb. But you don't have to go up against them alone. In Indiana, the law gives you real tools to fight back, whether it's working with their insurance, proving their negligence, or filing a lawsuit. You have the right to be compensated for what you've lost because of the accident. And let's be honest, companies have teams of lawyers and investigators. You deserve someone in your corner who knows the rules, has seen these tricks before, and won't back down. So if you've been hurt in a truck accident here in Indiana, don't accept the first small offer or let them tell you it's just an accident. You have rights, and there are ways to make these companies pay for what they've done. All right? Let's recap. We've just covered 3 ways companies can be forced to pay you after a truck accident here in Indiana. Number 1, going after their insurance. Number 2, proving their own negligence. And 3, if needed, taking them to court and winning a judgment. Each of these paths can work, and sometimes you need to do more than just one. to get the full compensation that you deserve. Now, if you're watching because you want to protect yourself or a loved one, you won't want to miss our next video. What happens when you are the passenger of an Uber accident? It's packed with must-know tips to protect your rights if you're ever riding in someone else's car and things go wrong. Don't skip it. Your health and your wallet could depend on what you learn. I'll see you over there.